Dear students of corporate and business law, we are in business law discussion. So let us start the module. Third module under business law is the Negotiable Instrument Act 1881. And as you know, this act was introduced in 1881 and the act number is 26. The issue of the year is 1st March 1882. There are 31 definitions in this act and there are 17 chapters and the total number of sections is 141. So let us discuss about the chapters. There are 17 chapters, so let us see. The first chapter includes the preliminary of this act and all the definitions are discussed here. The second chapter is of notes, bills and checks. So notes means promissory notes, bill means bill of exchange and checks. So next, the third chapter, and which discusses about the different parties. Already we told that the negotiable instruments includes 3 different instruments. All is promissory notes. The next one is the bill of exchange and the third one is the checks. This third chapter discusses each and every one. The fourth chapter is of negotiation, that is how these instruments are really operates, that really we'll discuss in this act. And then the presentation of these instruments for collection of the money as well as payment, that discussed in the 5th chapter. And the 6th chapter about the payment and interest part during this instruments distribution process. So that discussed under the chapter 6. The next chapter is 7 and that is of discharge from liability of promissory notes, bill of exchange and check. That has been discussed. The 8th chapter of notice of dishonor. If any instrument like promissory note, bill of exchange or check, if any dishonor is there, then what are the process to resolve this part, that is discussed under chapter 8. And then chapter 9 of noting and protest, that has been covered. Next, chapter 10, that is reasonable time, that is the question of the justice. We know that justice delayed, justice denied. So that has been discussed under chapter 10. And the next one is the 11th chapter, that is of acceptance, payment for honor and rejection in case of need. That part is covered here. And the 12th chapter is of the compensation, that has been covered here. And then 13 is nearly special rules of evidence. Then 14 special provisions relating to checks particularly. And then 15 special provisions relating to the bill of exchange. And the 16 the international law, especially particularly these instruments, the promissory note, the bill of exchange and the checks. And the last chapter is the 17th chapter, certainly like other laws, that is the penalties in case of dishonor of the certain checks for insufficiency of fund in the accounts. That has been dealt with the 17th chapter, and that is the last chapter of Negotiable Instrument Act 1881. Dear students, let us introduce the Negotiable Instruments Act 1881. So first of all, the introduction. So at the very beginning, let us have an overview on the act. So an act to define and amend the law relating to promissory notes, bill of exchange and checks. That is the 3 cornerstone of this law. And then why this law is very important? It is because it governs negotiable instruments in Bangladesh, ensuring legal clarity in financial transactions. That is the background of this Act, Negotiable Instrument Act 1881. What are really the scope and the extent? You see the picture. I mean, that was basically history tells about 200 years and more than that. So it is applicable to different areas, particularly the geographical coverage or application. You see, it extends the whole Bangladesh. And then how really this act executes. That is, it does not affect provisional of Article 23 and 24 of Bangladesh Bank Order 1972. So the scope is very wide and the extent it is also very wide. The Negotiable Instrument Act 1881, it is applicable in Bangladesh as well. So definition of negotiable instrument, that means what does it mean? So the way the Act defined these instruments are instruments that guarantee the payment of a specific amount of money either on demand or at a later date or on a particular date or particular time. That is basically the definition of negotiable instrument. And what are the different types of the instrument? So there are three mainly especially covered by the law, but there are some other instruments also, especially in our study manual of ICMAB. But three core negotiable instruments are promissory notes, bill of exchange, and checks that is applicable in Bangladesh. Then let us go one by one. What is really the promissory note? That is the first negotiable instrument, and the Act is so old. I mean, 100 years we have passed by this time. So how we can define promissory note? So it is told in the Act that an unconditional promise in writing to pay a certain sum of money to a specific person or bearer of the negotiable instrument. And what are basically the key features? So it must be in writing, signed by the maker, and contain an unconditional promise to pay. That is basically the key characteristics of the instrument known as promissory note. The second negotiable instrument mentioned in the Act is bill of exchange. So what do you mean by bill of exchange? So bill of exchange is an order in writing addressed by one person to another, requiring the person to whom it is addressed to pay a certain sum of money to a specified person or bearer of the negotiable instrument. And the fundamental characteristics or features of bill of exchange: it must be in writing, signed by the drawer, and contain an order to pay. That is basically the key feature of the bill of exchange. Check is an example of negotiable instrument, and it has been being used for even 100 years. So what do you mean by check? Certainly, check is connected to the bank, the depositor, and also the bank, and also the payee. All are the parties especially linked to the check. So what is the definition? How we can define check? So check is also a kind of a bill of exchange by negotiable instrument drawn on a specified banker and not expressed to be payable otherwise than on demand. So what are the key characteristics of this negotiable instrument? So it must be in writing, signed by the drawer, and payable on demand. So there are also case related also here, the lawyers and jurists, and after that it was the decision that negotiable instrument like promissory note or even bill of exchange, check is also will be treated as a negotiable instrument. So holder and holder in due course. This instrument, who will hold this, he will be called as a holder. And there are sometime it is also needed that holder in due course. Holder means a person entitled in his own name to the possession of a negotiable instrument. That means negotiable instruments means promissory note or bill of exchange or check. So who will hold it? They will be known as a holder. Holder and due course, what does it mean? So it is also related with the negotiable instrument, all the negotiable instrument like promissory note, bill of exchange or check. So a holder who has taken the instrument under a specific condition including good faith and for value, that they will be called in holder in due course. Negotiation and transfer. You see, since negotiable instrument, that is why negotiation is also important and the methods, that is also important. So let us see negotiation. So the transfer of a negotiable instrument in such a manner as to constitute the transferee the holder thereof, and the methods by endorsement and delivery for order instruments or by delivery alone, that is for bearer instruments, that is the method, that why the negotiation will be settled. Endorsement. So it is a definition also mentioned in the Negotiable Instrument Act under Chapter 1. So let us see how we can define the endorsement. So endorsement is an act of signing the back of a negotiable instrument to transfer it to another party. And there are different types of endorsement like blank endorsement, full endorsement or restrictive endorsement. So there are three types of endorsement is also included in the Act under definition of the Negotiable Instrument Act. Crossing of checks. You see, there is a check and it may be crossed, it may not be crossed. If it is not crossed, then the holder of the check, they will withdraw the money from the bank in his own name. But if the check is crossed, it means that the holder must have an account in the bank and he or she will deposit the check in his or her account. So they cannot encash it from the bank directly. So how we can define it? Crossing of checks. So drawing two parallel lines on the face of the check to indicate that it must be deposited directly into a bank account and not cashed over the counter. So this is called checking the crossing the check. And what are the types of check crossing? There are general crossing or there are also a special crossing. There are two types. Dishonor of check. That means if you go to the bank with a check and bank may not agree to encash it. Why it is? Let us see. When a check is returned unpaid by the bank due to insufficient funds in the account or there are other reasons. Maybe the signature on the check is not tally with the check kept with the bank, or maybe there are duplicate lines, or maybe the amount is not same, or even the money available in the bank and in the check maybe the money is higher than the deposit of the bank. If it is, then that will lead to dishonor of the check. So what are the legal consequences? It may lead to penalties under Section 138 of the Act. That means Negotiable Instrument Act under Section 138, it is mentioned that if any check is dishonored, then the consequent party may be penalized as per the law. So what is really written is under 138, dishonor of check for insufficiency of fund. If it is, then it is a criminal liability for drawer. So 138 section of Negotiable Instrument Act 1881, it is mentioned that it is a criminal liability. Why it is? It is because drawer, if a check is dishonored due to insufficient fund, that means it is a responsibility of the drawer who signed the check. Because until and unless you check with the balance of the bank and you are writing such an amount which is very much higher than the deposited money, that will lead to dishonor of the check. So what is the punishment? So in the law, it is mentioned that imprisonment of up to 2 years or fine up to twice the amount of the check or both. That is the punishment mentioned in the law. So liabilities of the parties. That means the drawer who signs the check, the person who makes or signs a negotiable instrument. Drawee means who is holding the check, person ordered to pay the amount, that is bank in case of a check. Payee, person to whom the amount is payable. So these are the three different parties, and their liabilities is mentioned like this in the act. It's mentioned. Then presumptions under the act. Presumptions means every negotiable instrument is presumed to have been made or drawn for consideration. And presumption as to date. Instruments are presumed to be dated on the day they are made or drawn. That is the fundamental foundation of this act, and based on this we have to resolve the issue. So material alteration, what does it mean? That is also very, very important for this Negotiable Instrument Act 1881. That is any change made to a negotiable instrument that affects its validity. I mean, the negotiable instrument already prepared, but later on it has been changed, alteration, and material alteration. If it is, then the validity of the instrument will be a question. And then effect. And instrument with material alteration is void. We have already earlier we discussed that valid contract, voidable contract, and void contract. So in such a situation, the instrument will be void if any material alteration is done, unless the alteration was made with the consent of the parties involved. Then not negotiable instrument. Already we have mentioned that there are three instruments are negotiable instrument, and not negotiable instrument means instruments that are not transferable by endorsement or delivery. Examples: instruments marked with not negotiable or account payee only. Sometimes we have seen in the check, then there is a cross, and within the cross it is written account payee only. What does it mean? It means that it will be deposited in the drawee's bank account. Electronic negotiable instruments. I mean, now we are in the age of information technology. So earlier it was done with manual process, but nowadays there are also electrical ways someone can do electronic negotiable instruments. So with technological advancement, electronic negotiable instruments like a check have emerged. A legal framework governed by the Payment and Settlement System Act, which is 2007, and then with provisional forms the Negotiable Instrument Act applicable to dishonor. So these are basically a new development, and due to the promotion of the information technology, the manual system is gradually becoming redundant. So we have to also change ourselves, and the process we have to adopt over a period of time. So amendment to this act. 1988, there is an amendment of the negotiable instrument, because originally the act introduced particularly in 1881. That means after 107 years, there is an amendment. Introduced provisions for criminal liability in case of dishonor of checks. That was not included earlier, but later on it has been introduced. Then also in 2002 there is also an amendment which is addressed issues related to check, and also the digital transactions. So this is also gradually introducing, and then the amendment to the act, that is okay. I mean, in 1988 there is the first amendment, and the next 2002 there is another amendment, and particularly if we are gradually converting our business transactions from manual to the electronic process, then certainly the changes of the laws are also equally relevant. So Negotiable Instrument Act also amended its situation from time to time. Then importance in commercial transactions. You see, the bank business, insurance business, each and every day there are so many transactions in commercial lending process. So actually how this negotiable instrument helps, why they are so important. It is told that these instruments facilitates trade. That means it enhances the trade, commerce and industry as well, because it provides a legal framework for the use of the negotiable instruments in business transactions in Bangladesh. It is not only applicable in Bangladesh, it is also applicable in the rest of the world. And this instrument also ensures security. It offers protection to parties involved through legal preassumptions and liability settlement as well. A case study, which is dishonor of a check. So there is a scenario, let us see. A check issued for payment is dishonored due to the insufficient of funds. If this is the situation, then what is the legal action? The legal action is that it is already, we have discussed the section of 138. In there, certainly the legal proceedings will start, and for this, I mean, the drawer of the check, I mean, who wrote it, so there is a punishment, and the punishment is that it will be a fine, and fine is the double amount of the amount, and that is basically the punishment mentioned in the law. And legal remedies. So there are two types of remedies due to the offences. So there is one is civil remedies, that is recovery of the check amount through civil suit. If the check is dishonored, through civil suit, I mean, the person who can really demanding the money, he can recover from the drawer. So that is called civil remedy. Going to the court, you can recover your money. And there is also another remedy that is called criminal remedies. That means prosecution under section 138 for dishonor of check is given. Challenges in implementation. That is, the Negotiable Instrument Act, it is also faces some challenges. That is called awareness building. Lack of awareness among the public regarding the provisions of the Act. Because people, especially at large, they don't know about this Act. So it is needed, particularly the level of awareness, it must be increased, and the authority can take some actions. And also enforcement. There is also another challenge. The challenges in this timely enforcement of legal provision is also a part to implement these laws. I mean, we are very much at the end of the Act, so we have to have future outlook, because the massive digitization is taking place throughout the whole country. Our number of smartphones increased a lot over a period of time. The promotion of the Bikash, Nagad, Rocket, all these financial transactions are going on. So during this process, I mean, our future is the digital world. We are very much part of the digital world. So integration of digital negotiable instruments into the legal framework, that is also important. which is not yet done yet, and the reforms. That is also very important and necessary. That is potential amendments of laws to address emerging challenges in financial transactions in future we have to take into account. So finally, we are very much at the end. So we conclude that the Negotiable Instruments Act 1881 plays a crucial role in regulating negotiable instruments in Bangladesh, ensuring legal clarity and protection for parties involved. So let us call to action, encourage future study and awareness of the Act to promote lawful and secure financial transactions made by the general public. So we have to protect them, and that is the focus in the law, and the changes coming on with the interaction with the present need and the changes taking place throughout the whole country. We have to have a kind of balance between these two. That is the most important and essential necessity at the moment.